It's one of those gotcha questions, because in the event that you are an individual to which this might apply, if you answer yes, you get denied automatically.
Yep.
If you answer no, and then something happens to you later on, and they decide, aha, he answered no when
Yeah,
he
he
really
lied on
should
the
have answered
form.
yes. You lied on a form.
We are the Armed Attorneys. Today we're talking about Mary Jane, the Devil's Lettuce, and gun rights. I don't know what's going on, if there's been some kind of heated discussion on the Facebooks, on the Reddits, on the X, but this seems to have come up. We've had several attorneys talk to folks lately asking, hey, maybe, hypothetically, if someone was a user of THC products, marijuana, how would that impact their gun rights? So we're going to be going through that, going to be talking about, are there some pitfalls and dangers when it comes to maybe a medical marijuana card? But before we begin, show your support for the Second Amendment. And today's video is sponsored by Aura. One reason we all receive so many spam calls and texts is that data breaches are happening more and more often. And what's worse, companies aren't telling us about them fast enough. In fact, Bank of America recently announced a data breach. What's even more disturbing is they didn't tell anybody about it for months. On average, it takes a company 277 days to report a breach. That means your personal data could have been exposed months ago and you're only just hearing about it now. And breaches aren't new. Last year, Citigroup and JP Morgan Chase both announced breaches. Your data could be compromised right now and you could be months away from finding out. Do you want to give the criminal a 9-month head start? That's why we're excited to tell you about today's sponsor, Aura.
Or alerts me if they find my phone number, email, or social security number on the dark web. They'll also let me know if anyone tries to use my information to access my credit or bank accounts. And if the worst case scenario happens, Aura will provide up to $5 million in identity theft insurance to help cover the damages.
Aura also includes a VPN, password manager, real-time credit and identity theft monitoring, internet parental controls, and malware protection, all inside one app. And unlike other companies that take nearly a year to notify you, Aura works fast. Because let's be real, most companies' idea of helping is just offering a free credit monitoring after the fact. That's like installing security cameras after your house has been burglarized. It's great if you haven't been a victim of identity fraud yet, but why keep rolling the dice? Let Aura do the hard work of keeping you safe online. Go to aura.com/armedattorneys to start your 14-day free trial today. Edwin Walker of Edwin Walker fame, how are you doing?
I'm doing all right.
Well, I don't know what prompted this, but we had a lot of folks say recently, call in, asking about gun rights and marijuana, how these two things intersect. And I think it's worth starting with, there's not a whole lot of agreement between the states and the federal government.
Well, yeah, and this has been an issue for a while. I mean, we're already. I think that the Form 4473 was revised back in 2017
Sounds right.
to include the marijuana language, the language that just because your state may have different laws on marijuana, it's still considered a controlled substance by the federal law. So this has been an issue for a very long time. I think over time we see resurgences of, is this going to get people in trouble? Is this going to change? Is the new administration going to change? When is the federal government legitimately going to revise its marijuana laws? So it's just one of those things that just keeps bubbling up under the surface until either the U.S., either the Congress or the Supreme Court weighs in.
Yeah, and I'll say probably, maybe what's triggered this is we got a lot of legislatures in session. Everybody says, oh, it's going to get legalized this session. That might be one thing. We have a change in presidential administrations. We saw the Biden administration not really, they didn't seem overly concerned with marijuana. Not when it relates to guns. They definitely cared about that stuff. But just in other kind of contexts, they didn't seem to pay that much attention to it. So, change in administration. Hey, is there a new focus here that we're going to crack down on this stuff? So, maybe that's what's triggering all of this. But I'll say, a lot of states have legalized cannabis, marijuana, THC. I know that there's specific definitions under federal law. I'm just using all those words kind of interchangeably. Don't hold it against me. But still prohibited under federal law. A lot of states have legalized this stuff. Which law controls?
Well, right now, for purposes of for purposes of enforcement by the federal government, obviously the federal prohibition controls. Now the question is does your is your local law enforcement officer going to be and if you happen to be in a state that has relaxed marijuana laws, is that local officer either going to be motivated to, or is he authorized to, once he finds somebody in possession of a firearm and simultaneously in possession of marijuana, turn that case over to the feds to be prosecuted?
Well, the answer is yes. I mean, you have these kind of dual jurisdictions issues with also, I mean, a supremacy issue. But, if you commit a crime that's both a crime under state and federal law, guess what? The state can prosecute you, the federal government can prosecute you. If the state decriminalizes it, well, maybe the federal government is just left there prosecuting. So even in these states where it has been legalized or decriminalized, or maybe they have some alternative program, um, could the feds come in at any moment and say, hey, guess what? State law doesn't matter. We're going to prosecute you for this stuff. The answer is yes. Do we see that happen a lot as a practical matter? Not very much.
Well, most prosecutor offices are in communication with the U.S. attorney's offices for their district, and here in Texas, I will tell you this comes up quite often with regard to the felon in possession of a firearms laws, because in Texas we have a very unique position that a felon can be in possession in their house, completely counter to the federal law that says no felon. And so oftentimes we'll see the prosecutors say, hey, we got this person, we can't prosecute him. Do y'all want to prosecute him? And many times the federal government turns it down. But you know what? The current interest in the marijuana may be in response to the recent Fifth Circuit decision talking about a person in possession of marijuana in Mississippi.
Yeah, the Daniels case out of Mississippi, and this has had a roller coaster history. We'll throw that up on screen just so you folks can go check it out. But essentially, this was an as applied challenge, so this only applies to Daniels, doesn't apply to anybody else. This is a facially unconstitutional challenge. Asked to have his case dismissed because, hey, guess what? We're looking at the prohibition under 18 USC 922 G3, this prohibition saying, hey, you can't possess a firearm if you're an unlawful user of or addicted to any controlled substance. And the court said, nah, you're convicted of this stuff. Jury convicted him. He appealed it up to the Fifth Circuit. They reversed the case, saying, hey, guess what? As applied to you, this is not going to be, this is not a constitutional infringement on the Second Amendment. Well, the Fifth Circuit, this is what's crazy about this case. The Supreme Court granted certiorari, reversed and remanded it back down to the Fifth Circuit to figure it out again, and they came to the same conclusion again. Hey, guess what? We applied in light of Rahimi. We applied this new case we have out of the United States Supreme Court, and we came to the same conclusion. That's where we're at right now. Is something going to happen in future with Daniels? I don't know, but I'll say in the Fifth Circuit at least, now there's a question. Hey, this federal law, this prohibition, 18 U.S.C. 922 G3. I mean, it's not facially unconstitutional. It's as applied, but I mean, the conditions to meet it sound pretty crazy.
Yeah, and that's the thing about it is, so the Fifth Circuit may not have struck down the entire law. So they're not saying that 922 doesn't apply. With regard to marijuana and possession, being under the influence of controlled substances. However, it seems that under the conditions that Daniels has won would apply to most ordinary people who would be caught in a similar situation to Daniels. He was just, he was in a car, he had a few joints with him, he had a gun.
He admitted to smoking basically every other day.
Right. What's what they say, 14 days a month.
Yeah.
They actually quantified it as 14 days a month. And so they said, yeah, it's unconstitutional. So I really doubt that in the event that somebody was similarly situated, that they would have a decision different than Daniels. The trouble is that since it is an as applied challenge, it's incumbent upon every individual who is charged with this to fight their own battle. And so that obviously can be very time consuming, very expensive, and you have to linger for years and years and years under the fact that you are being charged under federal law with a crime, which
Yeah.
can be very debilitating to employment opportunities,
Yeah, it's gonna ruin your life.
housing. It's going to ruin your life. But at the end of the day, you may win just like Daniels did.
Yeah, because the standard, and I'm gonna get it wrong. Correct me. It's like the standard is continually incapacitated.
Yes, the
Is that
judge.
right?
Yeah, I think the judge
Okay.
said that yes, if you had an individual who was continuously
Yep.
incapacitated by marijuana, then they perhaps could be in violation of this law. So, who are some folks that we would imagine would be continuously incapacitated?
I don't know. Who do you think?
I don't know. I mean, there's
I mean,
several.
most people. I mean,
Put your thoughts in the comments below.
yeah. I mean, I'm scratching my head here. I mean, yes, I'm sure there's someone who is continuously incapacitated by marijuana, THC, cannabis. I don't
I don't
know.
know. Well, maybe somebody who's
You looked at me like I knew someone, and you're like,
maybe
"Hey, do you know what I'm talking about?" I
maybe
don't know who you're talking
maybe
about.
someone who has crafted a public persona of being continuously
Ah, you're talking like the
incapacitated,
Snoop Dogs and the Nelsons, the Willie Nelsons of the world.
and the Cheeches and Chongs.
Sure, yeah, okay, but perhaps.
Yeah.
But all right, so we have this. All right, maybe even if it's criminalized under federal law, Fifth Circuit, maybe we'll see some other circuits who kind of agree this unlawful user of or addicted to language is a little vague and ambiguous. Who does it, what does that really mean? Continually, incapacitated? Maybe in the Fifth Circuit it does. But we still have this issue with firearms transfers, the ATF Form 4473. We're going to go through that real fast. And then let's talk about marijuana cards a little bit. But, when you purchase a firearm from a federal firearms licensed dealer, an FFL, gun store, you have to fill out a firearms transaction record. And they have this list of questions. It's question 21 and it's ABCDD, and it just keeps going. And question F has a specific provision. It says, are you an unlawful user of or addicted to marijuana or any depressant, stimulant, or narcotic drug or any other controlled substance? Warning, the use or possession of marijuana remains unlawful under federal law, regardless of whether it has been legalized or decriminalized for medical or recreational purposes in the state where you reside. So that's that language that you were talking about earlier. So, you have this person. Could they go into the gun store if they aren't continually incapacitated by marijuana? How do they answer that question, do you think?
Well, yeah, it's one of those. It's one of those gotcha questions, because in the event that you are an individual to which this might apply, if you answer yes, you get denied automatically.
Yep.
If you answer no, and then something happens to you later on, and they decide, aha, he answered no when
Yeah,
he
he
really
lied on
should
the
have answered
form.
yes. You lied on a form. That's a separate charge.
Yeah, so you in that case you would get charged with not only the possession crime, but the lying on the ATF 4473 crime because yeah, now you've got two crimes here. And sometimes, I mean, I've seen them think about that gun dealer. God dang, I can't remember the case where it's basically they charge the gun dealer for writing the record down wrong, receiving the record down wrong, and then transferring the firearm. I mean, they'll try to cook up as many crimes as they can in here, but we see where there is some risk there. But they have the warning there. Hey, guess what? State law doesn't matter here. Look at the federal law. We don't have any kind of clarification from the Supreme Court on it, but we see this as applied challenge. Maybe some other people get some relief there. Now,
Yeah, and I know that a lot of people are concerned with how far will the government, the federal government, go into investigating this.
yeah,
So, is it possible that the DEA goes through, pulls a bunch of firearms records for a specific area, has a list of individuals who had purchased firearms? Suddenly, then they go stake out a local dispensary or so
yeah,
and just start running license plates while people are in the parking lot.
yeah. Hey, have you bought a gun? We see you showed up at this dispensary. That's possible. Now, I'll say where it's a little bit, and this is where the government's job gets easier, is with licensing, and that's kind of the last thing that we wanted to talk about. Now, a lot of states don't have complete decriminalization. They have some kind of intermediate, hey, compassionate use or medical use, marijuana, cannabis, THC, because it deals with all kinds of issues, even though the federal government says it has no medicinal value. But what goes off in your mind about, licensing from the government?
Well,
The
there's a
surprise, the surprise on your face. You went, whoa.
there's a record of it.
Yeah, it's a
So you
clear
have
record.
records. And whenever you have a record, so that the government can use it because it's a government document, and so you can show, look, you purchased a gun here. We know that you're licensed to consume marijuana for whatever reasons, because you've admitted that to the state. So would that be enough though to actually convict somebody, or would they have to have actually been found in possession of marijuana, or subjected to some sort of drug test where it showed that they had marijuana in their system?
Yeah, and so it's an interesting question. Going back to that, Are you continually incapacitated? Well, maybe that we'll just set that aside for a moment, but could the government use that as proof positive that you are a prohibited person? I've actually seen that happen with licensing here in the state of Texas. Texas does have a compassionate use program. We have folks who have medical marijuana licenses. I had a guy who zero criminal history, had a medical marijuana license, went and applied for his license to carry a handgun, and they have this big catch-all exclusion on your LTC eligibility is can't be prohibited under federal law from possessing a firearm. Even though it's okay under state law, the feds still think it's bad, and therefore you're going to deny your license to carry. So you do, I think there is some exposure there for folks who get these licenses.
Yeah, and I would also caution people. I know you brought Texas DPS in this. Texas DPS has a long and colorful history of denying people for literally anything they can dig up in their past, and so they are definitely at the extreme end of digging up stuff, looking at stuff, implying that things can
Inventing hoops out of thin air and making you jump through them.
exactly. So DPS is the most. What would you say?
I don't know. They get mad at Emily every time. She's in the Capitol right now for folks. Emily will be back in a couple of episodes. She's working hard in Austin right now for gun rights.
Yeah,
they love Emily, the
yeah,
DPS.
Yeah, so I know that y'all people love to comment about, oh, Emily's really let herself go. Emily doesn't look right. We get it. That's fine with your little comments.
Give us more of those, please.
No.
But we see there's a lot of moving parts here. Be cautious. State, federal law, we see how this stuff's affected. Licensing, maybe this is stuff you want to talk to an attorney about. How do your particular circumstances affect this? But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And always question and comment down below, especially that Emily let herself go. And until next time, we're the Armed Attorneys.